Hi, it's Toronto immigration lawyer Max Chowdhury, and I wanted to discuss an issue that emerges with already filed applications for permanent residency. That issue is the addition of a family member to an already filed application for permanent residency. A newly disclosed family member can seriously impact an application that is not finalized. Why does the government have this rule? It is to ensure that you are not trying to bring a spouse that is fake to Canada or a child that is a health burden in Canada. This rule can be harsh in application if you have already landed without declaring your spouse or child. The failure to disclose a family member can eliminate the person from ever being sponsored in the future if they have not been medically examined and examined for other admissibility such as criminal inadmissibility. This can affect the main applicant by triggering the process for a Section 44 report, leading to a removal order. This removal order triggers the loss of permanent resident status and getting deported for failing to disclose a relative such as a child prior to landing as a permanent resident of Canada. There may be a more specific impact on an express entry application where the motivation of the person to get married may be questioned. For example, is the person you recently married intending to live with you as a spouse after you settle in Canada? Would your points under express entry be affected by the additional spouse? Do you have sufficient settlement funds to be approved after an invitation to apply in light of this new additional family member? Can you declare the additional family member at the airport at the time of landing? This is a common question when people have obtained their visas and then disclose or attempt to disclose the existence of a person. You can, but if you do this, the case may be delayed and your landing would be delayed until your additional relative's admissibility has been determined. For example, medical and background checks. Thus, the plan to settle may leave you in a limbo kind of situation, preventing you from fully establishing your ability to legally work in Canada or secure more permanent accommodation, owing to the lack of a clear status in the eyes of Canadian banks, landlords, and potential employers in Canada. If you fail to declare a relative, then, in addition to the deportation order issued on the basis of misrepresentation, you would have to fight the loss of your own permanent resident status at the Immigration Refugee Board Appeal Division. If successful at the appeal against your own removal, can you eventually get your non-declared relative to Canada as a permanent resident? The answer is yes, as long as you file a humanitarian and compassionate application. If you have an ongoing permanent resident application and a relative, such as a spouse or child, that has been added to your family, you may want to contact us and avoid difficulties in the future. Similarly, if you have been subject to an allegation under Section 117 sub 9 sub D of the Immigration and Refugee Protection Regulations, contact Chowdhury Law Office. Thank you.